Anthony. This is Fox News.
Lawrence County depends on WDXE News. On the air since 1950. Is the legend. 95.3.
And it's time for Bulletproof Estate Planning with my friend Stan Pierchoski, Pierchoski Estate Law. Stan, it's another Friday, buddy.
Good morning, Jeff. Good morning. It is.
Yeah, and we're winding up the month.
Seems like this one came around quicker. I mean, just 7 days. It seems like it was here already.
I know. It went by fast. It seems like all the time goes by faster these days.
And it is the end of the month.
It is the end of the month.
I think in this, like the 5th Friday in this month, this is one month says.
It may have been.
Something
I think
like that,
it was. Yeah, I think it was.
End of October, and what is my house? It was 37 degrees this morning, and I look at 37 degrees and say that's 5 degrees above freezing.
Well, it's going to be quite a nice day, actually.
Yeah.
We're headed to 60 degrees or better.
That's what I hear.
And sunshine, and of course it's Halloween. A lot of people will be doing some celebrating on that.
And it has been so damp and gloomy for
Partying and
3
what
days. Yeah. No, I guess they did something on the square last weekend for the kids, like they call it trick or trunk.
Yeah.
And I think there's something else. There's more stuff scheduled. But we have scheduled at the theater tonight, and for the adults, not the young folks, but the adult. I mean, young adults and adults.
Yes.
We call it karaoke. So you can dress up and come to the theater, and it's a karaoke night.
Oh, okay.
But
that'd be a lot of fun. Now that's at the Star Theater on the Pulaski Square.
It is. Yeah.
Yeah.
And, they have a beer license now. They serve beer and hard cider.
Oh, I didn't know that.
Okay. What they have right now is some from a local brewery.
Okay.
And they have about, I don't know, 8 or 10 different flavors. And there's one, I love the title, it's called Son of a Peach.
That's funny.
Anyway.
That's funny.
So they have, but yeah, that'll be fun. I'm going to do some, I like to sing some songs. I like some Beatles songs, some Doors.
Are you going to participate in the
singing?
Singing?
Oh yeah. I mean,
why not?
Can't go and not sing, right?
I've never done a karaoke.
I usually like to get up there and sing a song just so that everybody can feel like they weren't the worst person that sang.
Yeah. I would like to try this. I've never been to an official karaoke type event.
And there's a buddy of mine will be there. We like to sing a song. We like to sing a Man for Man song. Do-wah diddy. That's a real sing along. That gets the crowd going.
Yeah, it does. Yeah. Well, that's fun.
Yeah,
that's
fun.
a lot of fun.
So, anyway, that's at 7 o'clock tonight for 2-3 hours. 7 to 10, I think is how long we got that.
How good is that? There'll be a lot of folks come by there, I'm sure.
Yeah, dressed up too.
Dressed up.
I still haven't quite figured out what I want to wear. My wife and I are kind of stumped on what to do. We better figure it out soon because it's tonight.
Yeah. Well, you could go really scary as an attorney.
I was going to say, I told my wife I could dress up like a lawyer.
I had to do that to you. I'm sorry.
That's all right.
There's lots of lawyer jokes.
Really, that's right. Really scary.
Really
dressing up like a divorce lawyer.
I told
there are a lot of lawyer jokes.
Yeah, good deal.
I think I told it 1 or 2 on the air before.
Oh, I'm sure. Yeah. Yep. So what's going on in the estate planning world? Well, you've got a seminar.
I do.
A little ways away yet, but
just about 3 weeks. It's November the 22nd, so that makes it about 3 weeks from tomorrow.
Mm-hmm.
And it's a Saturday one, of course. And Saturday ones we do at 10 o'clock, and it's called Wills, Trusts, and the Nursing Home. And that's what we're going to talk about. And it's up a little bit farther north this time, up in Franklin, so it's at Williamson County. And it's actually at the Williamson County Public Library. And that physical address is 1314 Columbia Avenue in Franklin. And it's a pretty nice drive up there, and it's a pretty nice venue. And like I said, it's at 10 o'clock, starts at, on the 22nd, it starts at 10 o'clock in the morning. So
very good.
I'll bring that up again at the end of the hour. But yeah, it's not, it's 3 weeks out, but it's sure not too early to RSVP. We got a lot of folks on that are coming already. And so, there's plenty of room, so I don't think that'll be a problem.
Okay.
And that's sort of what we're going to talk about. Just to give a quick synopsis, I started out by talking about what a will is.
Yes.
Okay? And what it does, the formalities of it, and that sort of thing. Then I kind of shift gears to what a living trust is. What it actually physically is in the first place, and what it does, and how it solves all the problems that I point out that a will has. And then we talk a little bit about the probate process.
Yes.
Which goes part and parcel with the will. And that's something that the trust will allow the probate process to be avoided.
Okay.
Then, then we start shifting about midway through the seminar, into the concept of long-term care and the cost of it, and then how to avert the cost of it, and how to protect your property. I heard you I was listening to you on the way in,
Yeah.
and you mentioned it, it's gotten you thinking about things like how we protect our stuff.
Sure.
And that's exactly what that's about, is how can you protect your stuff. And in the instance that something would happen to, you or Teresa, along the lines of long-term care. Now, when I say long-term care, a lot of folks say, "Well, I'm never going to go to a nursing home. I'm not going to do that. I'll be taking care of it at home." And I get that. There's a big movement called age in place, and who wouldn't? Who wouldn't want that?
Right.
Most people that end up in a nursing home it's their circumstances that put them there, not their will to be there. As a matter of fact, I bet if I went there right now and took a poll and said how many people enjoy being here, or want to be here, or have elected to be here,
Right.
I don't think we get too much of a show of hands. But it's a reality that's possible, and here's why it's possible. I mean, I keep up with some statistics. Usually, I'm not a big statistic fan, but it's always been, as long as I've been practicing estate planning. You can Google this yourself. That it's 70% of people that are 65 years or older will have to be enrolled in some form of long-term care. Now, when I say some form of long-term care, there's a couple levels of it. One is, the full-skilled nursing facility, which is at the nursing home, right?
Yes.
Then we have something called assisted living. We have a couple what we call waiver programs. So we have assisted living, which is long-term care. It's just a lower level of care, meaning you can do some things for yourself. The way they gauge the need of care, there's quite a few things involved when they make that analysis. But we have these things called ADLs. It stands for Activities of Daily Living.
Yes.
And I think there's 8 of them. And it's like bathing yourself, clothing yourself, dressing yourself, toileting yourself, feeding yourself, getting up and walking, being able to give yourself your own prescription medications if you have it.
Right.
I think there's like 8 of them. And if you need help with 3, maybe 4 of them, you qualify for a full-skilled nursing facility.
Sure.
And so, but if you only need help with 1, or 2, then you could be a candidate for assisted living. Because in assisted living, you're it's not like a room in a nursing home.
Right.
Where, when you go to a nursing home, some are very nice, but when you get to the rooming situation, it kind of looks like a hospital way. You got a hallway and you got rooms and people in it, but there's not kitchens in the room or extra other rooms or a TV room or something like that. When you go to long-term, assisted living, it's a little more of an apartment setup, a little place for you to live, and you get help with what you need, but you're able to do the others. So it is a long-term care. And it's to become eligible for it is almost identical to nursing home eligibility.
Yeah.
It's billed a little different because it's a waiver program, but other than that, it's kind of the same thing. Then we have another form of long-term care called home and community-based. And that's where you can get some money to hire people to come in and help. So that's somebody that needs help with even less help and can stay at home, just need a little bit of help for some of the things they can't do.
Yeah.
And so, but if you think of with the statistic that 70% of us over 65 are going to need some form of long-term care of those 3, that hedges against us, right? It's more likely than not that we will.
Yeah.
And the really scary statistic is that 7 out of 10 people that do go into long-term care will become impoverished within 12 months. That's the scary one, because of the cost.
Wow.
And so if we sit here today and say, well, I feel pretty good, my health is okay for my age or whatever.
Yeah.
And it's like, I'm not going to go into long-term care, and I sure don't want to.
Yeah.
I think everybody thinks that. But there's a real possibility that could happen, looking at those statistics.
Sure.
Now, if it does happen, so it's kind of like, I hate to compare it to insurance, but why do you have insurance? Why do you have insurance on your home? Why do you have insurance on your car? I like to drive safe as I can be. I like to, I have to set an example so I don't speed and I don't do things I shouldn't do. But, accidents happen. Things happen that you don't plan on. And if that happens, you want to be in a financial position to mitigate, if not completely, almost eliminate the financial result of that, which is going to be a negative financial result. And so same thing with long-term care. If you end up there, that's not the time. That's not the best time to start dealing with your assets, because now we can still deal with that, and I've talked about it many times. But the best thing to do is this trust that I talk about at the seminar, because it's something you can do now, way in advance. And you get, and it's not like you're saying, well, I mean, don't look at it like, I don't really care about long-term care, so I don't want to do that trust. I want to do the revocable living trust. Now, some people do choose to do that, but keep in mind that the asset protection trust is a trust, and it works like a revocable living trust at death because you get all those probate avoidance advantages. You get the ability to control how it goes to your heirs because it's a trust. It controls how the property transfers, or what you put in it controls. So you get the best of both worlds with the asset protection trust. The only difference is during life, this trust, while you're still alive, this trust acts a little bit different. And there's a little more restriction to how you get not control, but access to the property.
Sure.
And we sort of lock that down a little bit, but still there's a way to do it. And that's the only real give and take part. So I know when folks are a little earlier in life, 30s, 40s, even sometimes 50s, they don't want that limited access just yet.
Sure.
And so they go with the revocable living trust. But don't look at it as strictly long-term care. You're hedging your bet. Now we're taking those statistics and we're creating a situation that if we are one of those 70% to go into care, that we're not going to be one of those 7 out of 10 that becomes impoverished.
Yeah, or it eats up all your assets.
We would have protected those way ahead of time, and that's just the best of all worlds. Then of course at death it acts like any other trust and doesn't go through court and all those advantages of the living trust. So, I mean, they're both living trusts. It's just one's revocable trust, one's the irrevocable asset protection trust. And I've talked about it. Maybe here coming up, I'll start.
Yeah.
Because when I talk about the asset protection trust, we kind of walk through it. It takes a few Fridays to do it, to cover it all, to unpack it. Maybe it's time to revisit that again. But,
sure.
But that's what we talk about at the seminar. I mean, a lot of people don't understand the limitations of a last will and testament. The whole reason I started these seminars, and that was some years ago. I don't know, 6, 7, maybe, gosh.
Been a while.
Time gets away from it. Maybe 8 years ago. I started doing these seminars, and it was kind of based on the fact that a lot of folks would come in to see me and say, I want to do a will. We'd talk about it, and I'd say, great. You want to talk about some other options than a will? And almost 100% of the folks said, I didn't know there was an option.
Sure.
I thought will is all I could do. And I'd say, well, there's a trust. And then I get responses like, well, I thought trusts were just for people who had a lot of money, rich people.
Yeah.
Or I've heard the word trust, I just don't know what it means or what it does. And these are very common responses, and people don't talk about trust much. I may be one of the very few that comes on public and talks about it because it's out there. It is an option. I think it's a better option.
Yeah.
When you hear the downside of having a last will and testament, I think you would agree with me that that's not the best thing to choose.
Right.
Especially when it avoids probate.
Right. Well, we have one of our regulars who wants to talk with us this morning.
Since we hadn't gotten started on anything, it's a good time.
Yes, I'm really interested in this kind of academically, but every time I talk to somebody, I get a little bit confused. Something that had come up, though, I found a list of things is why people are hesitant to do a revocable trust. And one of the things mentioned had to do with the 3-year rule on life insurance. And I had wondered if you might could give an example when it would be wise to put that in a trust and when not to. Evidently, if the person dies within that time, the trust has got to pay some kind of tax. That's one issue. A second has to do is the difficulty of making loans. Some people don't realize, or this is what I understand, that if they put assets in the trust, that it may limit personally their even being able to use any of that stuff. Well, I'm sorry, those things, unless they have the agreement of all their beneficiaries. But just things like that, if you give an example of, say, where that would be a good idea and where it might not, and does this even apply to what you're talking about?
All right. Thank you, Meg. All right. And by the way, the phone line is 766-9393 if you want to chime in with Stan.
Seems like we should have said that.
Yeah, we should.
It is a call-in program, so we should give the number like that. I just forget. I don't know why. Probably because the number is hanging on the wall and it's right behind you.
Yeah.
If I could see it all the time, I would think of it. Okay, so let's the revocable living trust and reluctance to do one. I don't know if any of those really apply, but I know of no such 3-year rule on life insurance.
Yeah, I'm not familiar
I
with
mean, when
it.
you talk about life insurance, you're talking about insuring you, your person, your life, right? So
Right.
you say, if I pass away, my wife gets, a couple $100,000
Right.
death benefit, right? I've never known, and I can't imagine why a life insurance company would have any interest or concern, or would even ask or care if you told them that you had your property in trust. Because remember, we put property in trust. That's what a trust, it holds property.
Right.
But a life insurance is not property, and you don't have it. If it's life insurance like term insurance, you have no ownership in it whatsoever. You don't own anything. So somebody said, "Well, I got a $500,000 life insurance policy, $500,000." It's like, well, that's great, but you don't own any of that. What you own is the death benefit. So
Right.
and you have to die for that to go to somebody before it goes to them. So you
Right.
have no ownership in that 500,000. So it's not something you can put in the trust, even if you wanted to.
Is there anything, and I don't know if this would even be done or not, but if the beneficiary of the life insurance policy was the trust, does that have any effect?
It does not. As a matter of fact, one of the things we tell people to do is if you have like let's say term life insurance, it's a beneficiary-driven instrument. You don't own it, you can't put it in, you have no equity in it. But what you can do is when you go to the beneficiaries, and typically you will name like the spouse as the primary, and then the trust as the secondary.
Okay.
And then it goes to the trust at death, and then the trust will control how that's distributed. Like if you have your children, say you got 3 children, they each get a third, it gets, everything gets distributed by the trust. So that is routine that we do. I have never known an insurance company to have an issue with it. Now, even if you have whole life insurance, you have some equity in what's called a cash surrender value,
Sure.
which is usually a fraction, very small fraction of what the death benefit is. But even those we don't put into the trust because we want to keep that insurance.
Yeah.
Now, the only time we would ever think about cashing that out is if we are trying to get eligible for long-term care. We've got a pretty good, $5,000 to $10,000 or $15,000 cash surrender value, and that's an asset they're going to expect you to cash in to pay for your care. So we have to deal with it. But I don't see the issue with life insurance. So there's no 3-year rule. I mean, the only 3-year rule I'm aware of is the look-back rule that used to be 3 years, which is now 5.
Yeah. All right.
Now, I will say there is something called an irrevocable life insurance trust. They call it an ILIT, I-L-I-T, for irrevocable life insurance trust. I don't do those. I'm not a big fan of them. I mean, they do exist, and I'm not sure if there's some kind of 3-year period associated with that because I don't do them. So I'm admittedly out of my lane on that. And don't really want to
Excuse me.
say that there's not that, but if that's possible, what they're talking about, because that is a trust that deals with life insurance. I've never done one. I know of them. I've read about them. We deal more with the assets. So
Okay.
So then there was.
The second question had to do with borrowing money,
Yeah, there you go.
or a loan or something like that. So how would a trust affect your ability to do that?
Well, actually, none. Well, let me put it this way. Let's start with the fundamental. When you borrow money,
Yeah.
whatever it is you're doing it, whatever you're doing it for, whoever you are and who the lender is, the bottom line is the lender has the final say. In other words, you go to a bank, they don't have to give you a loan.
Right.
I mean,
That's true.
Let's
Most of them really want to.
Let's come to that realization right now.
Right.
You have no entitlement when you go to the bank to get a loan, right?
Right.
You have no upper hand to play. I mean, it's their money. They decide if you're going to loan it to you.
Sure.
And what they do when you fill out the loan application, or they make you do a financial report or whatever they do, they're evaluating the risk. The
Right.
risk of getting paid back. And there's a lot of built-in things when you borrow money. Like let's say you just want to borrow money to buy a house.
Yes.
They will never loan you 100% of it. I mean, really, I don't want to say never, but extremely rarely. They will require you to put up a 20% down payment.
Yeah.
Now, when you think about that and do the math, if you put up a 20% down payment and then you borrow from them and they use the house as collateral, the equity in that house, and when you start paying back on the amortized table, the interest gets paid first.
Sure.
So if you do the math on that, the bank is never at risk, ever, because there's always more equity in the house than there is outstanding loan. So
Right.
they will not lose money on the deal. They can only make money. And that's the way banks are. Don't get, even if you work for a bank, don't call me and get mad. I mean, banks don't take risks. They're in the business of banking and making money on what they do. And there's nothing, I'm not downplaying that. That's what they do. But, okay, go ahead.
Well, here's a scenario that I was thinking that it might affect, and then you tell me if I'm wrong or not. But let's say I have a paid-for piece of real estate that owe no money on it,
Right.
and I place it in the trust. But I find another piece of property I want to buy, and I want to use my property that I've got in the trust as some type of collateral to secure the loan. How would that work, or does it?
It does, and it's just the same as it would be if it wasn't in the trust. Now,
Okay.
which you mentioned the revocable living trust, so that's
Sure.
what I'm talking about. You know, revocable, and the other stuff I was saying with the bank is just laying the groundwork that any loan requires them to say yes. So it's
Right.
possible if you had property in a revocable trust and for some reason they didn't want a loan, they could. But I've never really heard of it.
Sure.
It doesn't happen with some of my clients. In a revocable living trust, you have complete and unfettered control and complete and unfettered access to the property. So it's
Okay.
it's yours, it's in your trust. So the bank still has its remedy, whether it's in a trust or not, on a revocable living trust, the bank still maintains the remedy of foreclosure
Sure.
on a home if you use that, if you encumber that home for the loan.
Sure.
And so it's seamless. Okay, now there is, so I don't see a scenario where if you have property in a revocable living trust that they would have a problem with that.
Sure.
With the exception of maybe you have several co-trustors, and the bank would feel like if there's any property coming out in and out of the trust, usually the trustors have to be in agreement.
Yeah.
And so but I don't deal with those kind of trusts. The only co-trustors I ever have are husband and wife.
Okay.
Every once in a while, an elderly adult and a child, but
Sure.
not an issue. Now, one thing I want to say about these banks and loans is, in the old days, and I'm going to say back in the 70s,
Okay.
banks used to pull, they used to play a card that where if you put property into a trust. So right now I get a house, it's in my name, Stan Pierchoski. I put it in a trust and I retitle it to Stan Pierchoski, trustee of the trust. Banks used to say that's a change of ownership, and technically it is. Okay?
Yes.
And they say that triggers the due on sale clause. So you pay us the rest of the money right now that we loaned you. And that was so back in the late 70s, the federal law was passed called the Garn-St. Germain Act.
Okay.
The Garn-St. Germain Act says banks can't do that. That's because when somebody titles it to a trust, they're technically titling it to themselves. They're just putting it in the trust, okay?
Yeah.
They're going to say that you are prohibited under federal law to trigger the due on sale clause.
Oh, okay.
Now, if you sold it to somebody else, it still triggers that.
Sure.
But not a trust.
Running that all the time.
Yeah, and so if you have the loan, your example was suppose it's free and clear, and I want to borrow on it, and my answer was I see no obstacle or nothing in the way of doing that. I've seen many people do it, and I've never heard of a problem with that.
Okay.
Now, if you got crappy credit and they don't want to take the risk, I might say no, but it has nothing to do with the trust.
Yeah. Yeah.
Because that's available to them. Okay.
Yeah.
And the Garn-St. Germain says if it's encumbered when you put it in the house, which is probably more often than not when we deal with people, most people or a lot of people still have some payments on the note, and so there's an encumbrance there.
Yeah.
No problem putting that in the trust that way because Garn-St. Germain keeps that from happening. Now, the only thing I can tell you is now when we do the asset protection trust, which is an irrevocable trust, that can be a little different. That is, I'll go back to your example. We put a piece of property in there and you own it free and clear. You put it in the trust. Somewhere down the road, you want to borrow money on it.
Sure.
Now, that's why I laid the groundwork with the fundamentals and said it's up to the bank, because I have known some banks to not want to loan money when it's in that trust. Now, the majority of them do, because they understand how it works. But I know some that just have policy. When they have a policy, they won't discuss it. I can't talk them into anything. They just say that's our policy.
Yeah.
But in reality, if they would look a little deeper or wanted to not lose that loan business,
Sure.
they would find that if you borrow money on a home that's in the irrevocable trust, you have to carve out this creditor protection for that particular creditor, because they're going to loan money. They won't loan the money if in other words, they're not going to loan money to you if the property's in a creditor protection trust and now you just made them a creditor.
Yeah.
And so they get that, and so they will loan money, but you have to enter into a contract, which is the mortgage, to pay them back.
Sure.
And that's a contractual obligation. And so it carves out an exception for that.
There's always the paperwork,
Yep.
Stan.
Well, I'm just saying there's an exception for that.
Sure.
And so when you do the asset protection trust and borrow money on a piece of property, you cannot defeat the bank's remedies. And the remedy is to always foreclose if you don't pay the bill, if you
Sure.
don't pay for it. So, I have known some banks. Now, typically, some smaller local banks, I just feel like they don't understand sometimes and not real willing for me to explain it to them, but, because they run into this policy issue. But some of the banks that are everywhere, like the Wells Fargo's, the Banks of America, on and on like that.
Right.
Never have any problem with that. You can always find somebody that would do it. But I would say it's probably, there are some that don't do it under those circumstances. Where with a revocable living trust, I can't see, if a bank won't loan to somebody, it's for other reasons. They worry
Sure.
about payback reasons, or, they look at your income to debt ratio, and if you already have some stuff, the debts that you owe,
Yeah.
they won't loan, because that's how they evaluate risk. It's kind of a bunch of math.
Sure.
I don't know exactly what the algorithm says, but I know if you're gonna borrow, they look and see what your income is, they look and see what your current debts is, right down to your credit cards.
In the world that I'm in, the bankers and the lenders generally want to lend you the money, and they try to find any way they can do it within their rules.
And that's true, and because of what I said, they always have enough equity in the home, so
Yeah.
if even if you loan it to somebody of questionable reputation, they know that if there's a default, they'll still do okay.
If they can make the numbers work and you fit in the rules, then you will likely get the money.
That's right, and now that the interest rates are higher, there's more of that.
Yeah, absolutely.
So,
Absolutely.
I hope that answered the question. She said if any of this applies, and I just think the one thing at the end slightly applied.
I'm not familiar with the 3-year rule. There may be something that's applicable some other direction.
Like I said, I think in that islet I talked about. It's
Yeah,
possible.
maybe.
But I don't know. Like I said, I know when I'm out of my lane, and we'll say so. I don't do those, and I do know of them, but I don't practice them much. So there's a lot of, could be very many particular areas about that I'm not familiar with. But anyway,
We are in Bulletproof Estate Planning. Stan Pierchoski here is on our show, and of course it's actually his show on Fridays.
Yeah.
And the phone line is open to you, 766-9393 if you have questions or would like to ask Stan, but normally we've got plenty to talk about.
if it's my show, maybe how about let me get back behind the controls? They look
No.
Those buttons look like it'd be fun.
Listen, this thing is so finicky, I fought it all morning before you got here.
When I was here the other day with LB, there was some difficulty too.
Yeah.
Not so much with the radios, it was with the, what do you call it, the visual radio. The visual radio.
Yeah, sometimes that thing just has a mind of it. And I had to reboot the system when I got here this morning, first thing.
Oh,
So it kind of acted up on me. But we got it up and running today, so we're good.
So, just trying to think of what to talk about today. I know we had a 10-care approval come in over the week.
Oh, yeah.
And I think I mentioned this on this radio show. I do a couple and I don't remember. But I'm starting to get a feeling that, when I come in here, I used to talk a lot about some difficult cases that we had.
Yes.
And
Yes.
things we have to do, and things that went on appeal, and things that were problematic.
Yeah.
And it seemed like it's been that way for about the last 2 years.
Yeah.
Because before, I remember, things went through a lot smoother.
Yeah.
And now all of a sudden they just started, and I talked to other people on a estate planning forum that do the similar work, and
Yeah.
the consensus was the same. It seems like everything they send in, they got something to complain about.
Yeah.
And so, but it's been 5 approvals now. I think the one came in this week was 6. Got 6 approvals back there. If I go, my staff looks at them, they report to me, and they say, it was right around 90 days, the approval came in. They only made one informational request, which was the same boilerplate one they always make for this and that.
Yeah.
And they just got the approval. It went very smooth. And I'm just wondering, the pendulum may be swinging back the other direction.
That's good.
We're getting back into the things going relatively smoothly. So, it can only be some sort of management or the way they run the organization. It just seemed like all of a sudden they were just picking at everything. And I think maybe they thought that was a way to get less people eligible. I don't know. It
Yeah.
didn't work with me, at least the ones I dealt with, but
Yeah.
we got them all eligible. But still, I'm happy to report that. How long it'll last, I don't know.
Yeah. Well, maybe there's a new administrator there or something
I
that's
don't know. I wish-
overseeing things. You never know.
I'd love to be a fly on the wall sometime, but I don't know if I
I
can.
think I may have asked you this before, but where are they headquartered? I mean, where does all this reporting and paperwork go?
There's an office up in Nashville, and they have regional offices. There's one
Okay.
here for this region. I don't know physically where it is.
Okay.
I never deal with it. I never deal with it on that local level.
Yeah.
You send it in, Now, the local folks, I'm not even sure what they really do. I think they deal with a lot of, TennCare does more things than just long-term care. We have what we call the under 65 years old care.
Oh, yeah?
I deal almost exclusively with the 65 and older care, the long-term care that we're familiar with.
Yeah.
But when you're under 65, TennCare will pay, but you gotta have the disability or at least have applied for it. And TennCare considers itself the payer of last resort at that point. So you've got to do these things to get money coming in, and then they'll pay. I don't ever deal with it. Every once in a great while we deal with it, but not often. And they do other things. They have the Katie Beckett program. They have a lot of stuff for the pregnant mothers.
Right.
So I think that a lot of the regional offices deal with that, because when you do long-term care, either fax it in the main TennCare place, or you do it online on what they call the TennCare Connect portal.
Okay.
And I don't know who looks at that, to be honest with you. But the caseworkers we get, sometimes if I get talking to them, I've not known any that are right there in Pulaski or something. I think there is a place that serves both Lawrenceburg and Pulaski.
Okay.
I've just never been to it. Never had a need to talk to the individuals, because we do the application, we send it in, we get assigned somebody, and that somebody literally could be anywhere.
That's interesting.
I'm sure they're in Tennessee, because,
Yeah.
but I'm saying they could be anywhere.
Okay.
And it's always over the phone. Even the hearings are telephonic. I mean, everything, it's not like we go to court and it's a big, we do go to court, but it's a telephonic court, which
Yeah.
is kind of weird.
I think I was kind of fascinated when you first told me that you really don't ever have to go physically to a courtroom.
I mean,
it's all done through via telephone.
I mean, years and years ago, yes, I think that's the way we did it. But and it's different, because when I was doing law before I did this, I did a lot of criminal defense work, and I was a trial attorney, so I did a lot of jury trials.
Yeah.
And you're in that courtroom, you're in that environment, you can see your opponent can see you, you can see the judge, you can see body language, you can be facial demeanor, when you're ticking the judge off if you look at him, when you're making him happy. All that is not in the mix anymore, which it's kind of, I don't know, dehumanizes it a little bit, but I don't know, maybe it adds an element of fairness too, because it's a real level playing field for everybody at that point.
Sure.
But that's just the way it's done, and that's the way we do it. And, it gets done. I mean, you got the judge, you got the two parties. Of course, TennCare at the administrative level, it's the administrative hearing. It's not a jury trial. It's a bench trial, and the judge makes decisions and issues a written opinion. But if you ever want to appeal something, you can appeal it through the administrative level. But if you don't like that, if you want to appeal it further, you have to appeal it to Chancery Court in your district. And so then you get into court where you can actually appear.
That's interesting. That's very interesting.
My experience has been, unfortunately, and I hope they're not listening, but when I get to Chancery Court with an appeal, which is only, I want to say, twice. No, and how many times do we have to go that far to appeal?
Okay.
But you get to Chancery Court, now you're dealing with the Chancery, and they have that stuff never reaches their courtroom.
Yeah.
And so they're very unfamiliar with the rules.
Yeah.
And so you almost have to brief them, explain what then you have to write briefs about it where you really lay your position out. I mean, in every single detail what your thought process is, what authority you're relying on, what was done, and how what was done is outside of the authority or the jurisdiction and stuff like that.
Yeah.
And that helps a lot. And
wow.
Because they just don't ever deal with TennCare in reality on a day-to-day basis.
It's hard for those folks to be expert in every aspect of law.
Had a judge one time, he's retired now, he once accused me of blowing dust off of old leather-bound volumes of law. He came in and said, I had to blow dust off these old leather-bound volumes of law to understand what you were talking about in your brief. I wrote a brief. Of course,
I actually ran into two judges last night.
Oh, a party or something?
Well, one was a soft opening of a meat market here in town.
Okay.
And then we went to a restaurant afterwards, and there was another local judge here at that point.
Oh.
So I wasn't in trouble. I just had to go before two judges.
There you go. Did one of them have a natural radio voice?
One of them actually was.
I know.
You know who I'm talking about.
I know who you're talking about.
You know who I'm talking about.
Oh, he said he's got a natural radio voice.
Yeah.
Deep something.
Yeah.
Good man.
Yeah, he's a good guy.
I've known him since.
Him and his family have opened up a meat market here.
Oh, okay.
Yeah.
I didn't know that.
It's Piney Branch.
Okay, cool.
And so local beef.
There you
How
go.
about that?
like grass fed and stuff.
Oh yeah, good stuff.
Yeah.
In fact, we carried home some.
All right, good. I think I'll look into it.
Yeah,
Have my
you
wife
should.
look into it because, you know, I'm a fan of a good ribeye, and I mean a good ribeye.
Oh yeah, yeah.
I sometimes have the opinion if it's not a ribeye, it's not a steak. but on our anniversary, we went to a place in Huntsville, a place called Connor's. Which
Oh yeah.
and I got the last minute, instead of getting the ribeye, the last minute I got the prime rib. And I
Yeah.
was not disappointed.
Yeah. Well, there's nothing disappointing about Connors.
I will expand my thought process on steaks, and it now includes two.
Yep. Yep.
Of course, prime rib is kind of part of a ribeye.
Now I don't go to Connors very often, maybe once a year or something like that.
I just said it was our anniversary, so
but,
that's right, we do too.
But it is a fine steak, I will
Yep,
tell you.
Yep. So, all right, so do you have any questions you want to talk about?
Well, you've got me off on the steak now, so.
Yeah, that's right. Can't help you with that.
Well, you know, I just off the top of my head, I don't, but you have caused a lot of thinking on our process in our part because, and it is interesting to think about things like because you know it makes you feel like you're limited in what you can do when you think about putting all your assets into a trust. But you've clarified a lot of that, and so and one of those things is okay. What do you do if you've got all your assets in a trust and you want to use some of that ownership as a way to buy other property? So there's an avenue for that.
There is, and it gets used often. I mean, I know of
Yeah.
circumstances where people did, and I know the ones that went to some place that didn't do it.
Yeah.
You know, but I've always been able to find somebody to do it. It's really not that hard if you look. But,
Right.
But when you deal with the other trust, it's like nobody has a problem with it.
Sure.
You know.
Sure.
So, and the ones that have a problem with it, in my opinion, just don't quite understand it or just don't want to mess with it. You know, certain things you just don't want to. You can do and it's okay to do, but you just don't want to mess with it.
Sure.
You know, right into your personal life, things are like that. You know.
Yeah, absolutely.
It's like painting a room. I know how to paint a room and I can paint it, but I don't like to paint, so I just don't want to mess with it. It's not that there's anything wrong with it. I just don't, and I don't want to mess with it.
I don't like painting at all, and my wife just yesterday asked me about painting our basement, repainting our basement steps and the area around, going down into the basement and all that. So, the thing I'm going to do is call a painter.
There you go. You know, talking about real estate, you know, a lot of what we do in estate planning deals with real estate.
Yeah.
When you think about it, the people's home or the family farm or whatever, you know, almost everybody, once you get in retirement age, you own some land,
Yeah.
a house, or, I mean, maybe some acreage, maybe not. But it's a large portion of most people's estate. You know, and some people it's definitely the lion's share.
Sure,
You know.
sure.
And so, a lot of times I get this question that's like, well, can I put this property in trust and leave it to my children, and can I say that they have to leave it to their children, and then they have to leave it to their children, and stay in because they want it to stay in the family.
Sure,
You know.
sure.
And we see that a lot with farms. You know, farms that have been in the family for either generations or decades or a long time, and it's a working farm, of course.
Right.
And the theory is, hey, this is a working farm, a stream of income. We're going to keep it in the family. We've been working it all these years. It's a fine-tuned machine right now. We want to pass it on so it continues. And that's very popular in this neck of the woods,
Right.
where we are in the world.
Oh yeah, absolutely.
And the question is, yes and kind of no. I mean, we can do that. We can do the next best thing to that. Now, it's difficult to do what we call dynasty trust, where you just put property in a trust and say it goes to my descendants, and the descendants forever. You know what I
Yes.
mean? So my kids, their kids, their kids, their kids, forever.
Yes.
And there's a problem with doing that, and, although it used to be available, but you know, we have something called the rule against perpetuity. And you can't do something in forever.
Yeah.
Especially with land, because there's a thing called alienation of property.
Yes.
Kind of a dumb word. Alienation of property is actually the right to own and enjoy, buy, sell, use real estate, real
Yeah.
property. Okay. Where they get the word, I'm not sure. It must be.
It doesn't seem like it fits.
I'm sure it has a Latin root somewhere, but
Yeah.
it's called alienation. And to tell somebody, here's some land, but you can never sell it. I mean, you're not giving them all the rights in that land when you do that.
Right.
And to say you can never sell it ever in all time, the courts have ruled some time ago, and they will continue to rule that is an unreasonable restriction on alienation of property.
Sure.
Okay. And in other words, you can't. It's kind of like ruling from the grave. You can't give this to somebody and they can't ever use it.
Right.
Sometimes you can do certain things like that with the restrictive covenants in a deed. But
Yep.
that's not, you can't put in that you can't sell it. But you can say like you can't build more than one house per 20 acres or something like that.
Right.
And those run with the land, and those can hang around for a long time.
And they do.
And they do. And they usually run into people that don't like them, and then that affects the selling price because,
Yeah.
stuff like that. But, so the answer is you can't just do it that way, but there is a way to get close to the next best thing. I'm sure I talked about it before, but I know it's been a while. The way we can do it that seems to be the accepted way, and we don't know of any court cases that have shot it down yet, and that is you leave the property to your kid, and you leave it to them in trust, okay? So you can inherit the property outright when somebody passes away. It can just be outright, and here's the deed, or you can leave it to them in trust. So what you do is, if it's me, my trust creates a subtrust for my son at death, right? And I leave my farm or my property into the trust, in the subtrust for my son.
Yes.
And basically, the subtrust for my son says you can use the property, you can not use the property, you can farm it, you can do whatever you want with the property, but you cannot sell it, and you cannot. The terms of the trust that I left it in say you cannot sell it during the terms of the trust.
Okay.
Now, a trust has a beginning and a trust has an end.
Okay.
And so we don't violate the rule against perpetuities because the trust has an end.
Okay, I don't know if I realize that. So why does a trust have an end?
Well, because we can't have dynasty, if it doesn't have an end, it violates the rule against perpetuity.
Okay.
Okay, so it has to have an end. And so what you can do is say, you will put it in trust and you can't sell it for the life of the trust. Now, we can make the life of a trust pretty darn long in the state of Tennessee. I know I've talked about this before.
Yes, you have talked about this.
In Tennessee, the maximum it can be, now you can choose how long it can be. You can say I want it to be for 25 years.
Right.
Or 50 years. If nobody really wants it by then they can sell it, or something like that. But the maximum you can make it in Tennessee is 360 years.
Okay.
And we are not the longest state that has. You get to Nevada, where Sin City, right? You get to Nevada, they can do things for up to 1,000 years, which, in my opinion, 360 years is kind of close to perpetuity.
Yeah,
it's several generations.
That almost seems like it really doesn't have an end date.
It does, but that's what the legislature put in.
Interesting.
And so there's a way to do it, and that's the next best thing, And so we now sometimes this is a superficial review of it, but I'd like to discuss that with people when they want to do that to actually try to visualize the actual effect of that.
Sure.
If you got somebody, say you got 3 kids.
Yeah.
Say you got some land you want to leave them. One of them really doesn't want it. He's got his own life. He's somewhere else.
Yeah.
He has no intention of coming back from wherever he is and living on this farm because he's entrepreneur, he's successful in some other field, right?
Right.
The question is, do I want to give the land to that child under those conditions?
Yeah.
Because now it kind of burdensome to him,
Yeah.
He can't sell it. He's got to deal with it. He's got to rent it and do something
Yeah.
with it. He can do anything else but sell it.
Right.
And so, I'd like to, every now and then get some folks who are just adamant about that. And I tell them, this is going to be cumbersome for them. The whole idea of doing this is to make things smooth and better for them.
Sure.
So we can do that. I just think this needs to be thought through a little bit.
Sure.
We're pretty good before we do it.
Sure.
So I've had both ends of the scale. I had some people that said, I would hate for that to happen for me, and then I've had heirs that said, we're right there in the meeting and said, yeah, I think that's a grand way because we've talked about it. I'm going to inherit it. I have no intentions whatsoever of getting rid. They're on board with the concept of keeping it in the family. So people would say, yeah, if that's a good way to do it legally, I'm all in. But like I said, if you got that, that's one end of the spectrum. If you got kids that don't have anything to do with it, you've straddled them with a yoke of bondage, so to speak.
All right. This may be a dumb question, but if you set up a trust and you put an expiration of, say, 50 years, is there something or a remedy within that your heirs say, well, we want to dissolve this trust before then, or does it have to live the 50 years?
Well, technically, it has to live the 50 years.
Okay.
But it can be. It depends on how it's written, but technically I would think there is a way to revoke the irrevocable trust. And actually when the caller called, she mentioned something that only applies to an irrevocable trust. When you make an irrevocable trust, you say, I leave this to my kids.
Yeah.
The trust, now the beneficiaries have an interest.
Yes.
Okay, because of the type of trust it is. An irrevocable trust, if I say, leave my kids a third of my property, they don't have any right in that. I can change that with a stroke of a pen.
Okay.
They are beneficiaries at the stroke of a pen. If I get mad at them and say, I'm gonna leave it all these two and this one gets nothing, they can't come to court and sue, because the courts would say you have no standing, you have no right to enforce here. But when you, in an irrevocable trust, the beneficiaries at the creation of it now have an interest in the property because it's set to go to them.
Yeah.
So you can revoke an irrevocable trust, but you have to have all the beneficiaries agree to revoke it.
Okay.
So sometimes people will say to me, what's the difference between a revocable trust and an irrevocable trust? And it's a great question. And I've heard that question asked on TV and on the radio, and usually the person they ask to kind of shrugs their shoulders and says, I don't know, I guess one's revocable and one's not.
Yeah.
And that is not the answer. Now, I think it's an unfortunate name, because an irrevocable trust can be revoked, which sounds like legal double talk, right?
It
It's
does.
Like, okay, all right.
It does.
A lawyer talking out the side of his mouth, right? Well, I mean, our trust code is very clear on how to revoke an irrevocable trust. What I often tell people, the difference between a revocable and irrevocable trust is, on an irrevocable trust, you cannot be the beneficiary, the maker of the trust. And
Right.
that's what gives us the creditor protection right. Now, there's one other thing that goes with it, and that is you, the maker of the trust, cannot revoke it unilaterally. Unilaterally means by yourself.
Yes.
You must have all the beneficiaries' agreement to do it, because they have this interest now where they don't have on the other trust.
Okay.
So that's true if you, but it wasn't true in the sense that the caller said. It takes all the beneficiaries to borrow money on a piece of property or something like that.
Interesting.
So, but if you want to revoke it, you can revoke it, and I've done that on several occasions.
Wow.
What I've had was some trusts that people brought me that all the beneficiaries were on board with not having it, and it makes sense when you think about it, right? I mean, the word beneficiary means all this property you're leaving to the beneficiaries, for their benefit. That's
Sure.
where it gets its name. And if all of them figure it's not for their benefit and they don't want it, there should be a remedy to undo it.
Yeah. That makes sense.
But I mean, it requires all interested parties.
Yeah.
And if you have one that doesn't, it's going to be difficult. You
Yes.
can't move forward with that. So it can be done. I don't remember any time I ever had to revoke one of mine, but I have done some trusts that were brought to me that the people wanted out of it. So, and it's a kind of a process. You got to give written notice to everybody. You got to get a written response from them that they're on board with doing it, stuff like that.
Yeah. Now, and just off the top, does any of that have to be recorded in any way or just documented?
Just documented.
Okay.
Just documented. I mean,
Interesting.
where it comes up at is, like, let's just say we were revoking it for purposes of selling a piece of property.
Sure.
Usually that will get recorded somewhere, in, like the title insurance company.
Sure.
They would seek that out when they get it. They possibly, and in some cases I've known them to record that stuff to show what happened.
Yeah, and they're basically covering themselves too to show that they're.
Yeah, being in the real estate business, you're familiar with people buy property and hire somebody to do a 30-year title search. Right?
Yes, absolutely.
And that 30-year title search is to see if there's any encumbrances on the property.
Right.
And one of these trusts, like I'm talking about, that says you can't sell it for 360 years, is an encumbrance on property. It's
Yeah.
like you need to know that before you buy it.
That's right.
Because you may not be buying it if that's the case.
Right.
And so we find these things out. Now, when they find hiccups like this, like let's just say they find somebody who passed away. This happens to me a lot. People want to put property into a trust. We get the deed. We go to put it in trust. We find out their dad still owns it, and their dad's been gone for 30 years.
Yeah.
It just never changed. The person just kept living there.
Yeah.
Ownership indeed never changed. So you
Right.
got a defect in title.
Right.
And so you can go back and clean that up and get everybody that could have got the property when Dad died.
Right.
Just to do a quick claim deed saying we give up any right title interest we have in it. And then those things all get recorded so that it's 30 years from now, if somebody's doing a title search, I like to say a title search should tell a story.
Yeah.
And so you go back through these deeds and you find these things and you can see that the title is clean because of these actions that were taken
Yes.
when they cleaned this up. And
Absolutely.
if you find something that needs cleaning up, then you do it.
Yeah.
And so recording is not a bad idea. And sometimes they actually make them attachments to the deeds.
Yeah.
Just to show the chain of title. Because
And of course, yeah.
when you buy a piece of property, you want the title to be no cloud on
Yeah.
the title. Or if you buy it, you want to know what they are, so you know what you're agreeing to that goes with it.
Right.
Stuff like that.
And if the piece of property is actually in a trust, it will say so on the deed that it's owned by that trust.
Oh, absolutely. The way it'll look, let's just say, you and Teresa have a trust. You take your house, you put it in a trust. The deed that puts it in there The grantor, you know, you look at a deed, the upper left-hand corner,
Right.
there's some players. Grantor and grantee. The grantor, which is the person giving it up,
Sure.
it would be Jeff and Teresa, right? The individual. Now, the grantee is gonna be Jeff and Teresa, trustees of the Hood Living Trust.
Yes.
And so there it is right there on the deed. When somebody pulls the deed, they know exactly that it's, I mean, there's no misunderstanding that this piece of property is vested with a trustee of a trust.
Right.
And it's in there. So now when they sell it, they'll want some documentation to say, okay, do the trustees have the authority to transfer real property? And they'll look at something called the certificate of trust and probably record that says, you know, the trustees have the ability to do that.
Yep.
So they just, I mean, they just wanna make sure it's all, the i's are dotted, the t's
Sure.
are crossed, and that makes sense.
Run into it every day, as a matter of fact.
Yeah.
Very, very good.
And you run into a lot of correction deeds, cause things get done wrong, somebody misspells a name, or,
Yeah.
especially in the meets and bounds description, you know, somebody says 20 feet, and they slip a digit, and it says 200 feet, and it really isn't.
We run into, you know, doing these new surveys now. Sometimes you run into surveys that don't close, as they say.
That's right.
And it has to be corrected.
That was very common in the old days because they didn't account for up and down hills.
Right.
If you look at it two-dimensionally, they might not close.
Yeah, they might
But
not.
But you know, it was close enough, or more or less.
Yes, or more or less.
It's
Yeah,
just the classic language that they use. so.
absolutely.
Anyway, looks like we're, again, welcome to the fastest hour of my week.
It goes by fast.
But
It does.
looking at the clock, and we're just, so, hey, you know, this is what we do. If you want to talk to me about any of this stuff, you can give me a call at 931-363-7222, which is Pierchoski Estate Law, Pierchoski Elder Law, and we'll talk about it. If you want to go to my email, go to my website, estateplanstand.com. You can send me an email that way if you have a question. Or if you want to sign up to my seminar, the next one coming up, November 22nd, 3 weeks from tomorrow.
Yes,
And it's at 10 o'clock in the morning, called Wills, Trust in the Nursing Home, and that's what we'll talk about.
absolutely.
And that's going to be at the Williamson County Public Library. Physical address for that is 1314 Columbia Avenue in Franklin, Tennessee.
Franklin, Tennessee.
So it's a brand new venue for us, so it'll be interesting to see how it works. The girls have been up there and see it, and they say it looks great. They said it's pretty big. So we'll see that. And we get up there once or twice a year. This is the only time we've made it there this year. We had a venue that we used to use that kind of changed what it does.
Sure.
And so we were looking for one for a while. And
Yeah.
this one you had to book it way in advance, so that's why it's so late in the year.
What's
But
the date again on that?
November 22.
November
It's a
22.
Saturday. And then we probably won't have another one until later January, because we wanted to kind of hop over the holidays and that, you know what I mean?
Yeah.
Everybody's wanting to deal with holidays. Karaoke tonight. Karaoke is karaoke. That's supposed to be scary, not the songs, how you dress.
Yeah, you want to get in on that. That's on the Pulaski Square at the Star Theater,
It is.
which is next door to your
Yeah,
office.
7 o'clock
Yeah.
tonight, you know, for about 2 or 3 hours.
And if you want to hear Stan sing, he may be singing.
Don't come to hear that. Come to sing yourself and hear other people that know how to sing.
Going to be a lot of fun, I know. Going to be a lot of fun. Stan Pierchoski, Pierchoski Estate Law, located in Pulaski, Tennessee, on the square there. Not hard to find at all. That phone number, 363-7222, and the website, check it out, Estate Plan Stand.
And we are here every Friday morning from 8 to 9 for this show, and it's a call-in show, so
That's
if you
right.
formulate a question you want to ask next week, call it in.
See you next time, buddy.
Okay, bye.
This is WDXE W2.